Good afternoon. Welcome to the September 2023 Board of Zoning Appeals meeting. We're going to call this meeting to order, and Madam Clerk, if you would give us a roll call.
Curtis Brown.
Here.
Jonathan Repass.
Here.
Doug Lloyd.
Here.
Garrett Holt. Cecil Anderson.
Here.
Terry Kerr.
Here.
Sherry Garrett.
Present.
Rebecca Longmire.
Here.
Paul Huff.
Here.
Have 9 members present.
No, 8. Did you say we had 9 or 8 members present? We have 8, right?
4, 5, 6, 7, 8.
8. Okay, 8 members present. Oh, that's the new math, that's right. All right. Mr. Anderson, would you please lead us in the pledge?
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, members of the Board of Zoning Appeals are volunteers from each commission district. We do not receive compensation for our work on the board or training that we attend. As a quasi-judicial body, we avoid ex parte conversations and conduct our business in accordance with the Open Meetings Act. I'm Terry Kerr, the chair of the board. To my left is Ms. Longmire, and to my right is Mr. Moyers from the Law Director's Office. Steve, if you would introduce who you have with you today.
Yes, Steve Elliott. With me today, I have Kim Jarnigan, Kelly Vaughn, and we have Mike Reynolds from Knox Planning with us.
Thank you. Our voting procedure requires 5 positive votes for a motion to be approved, regardless of the number of board members that are present at the time of the vote, and today we do have 8 members present. I could have someone move to approve the minutes from our previous month's
I'll
meeting.
make a motion to approve the minutes.
And I second it.
Okay, we have a motion and a second. All in favor? Aye.
Aye.
Opposed? So approved. The Knox County Board of Zoning Appeals is authorized to grant variances and hear other matters by the Tennessee Code and the Knox County Zoning Ordinance. Specifically, these laws prescribe parameters required to grant a variance, and the burden of proving the grounds for a variance request rests upon the applicant. For each matter, the clerk will read the request into the record, and I will then ask if the applicant's present, and then I'll ask if there's any opposition or other speakers who wish to present. You don't have to come forward at this time. Once we determine the speakers for the item, we'll call on governmental agencies such as Knox County Codes, Planning, or Engineering to make statements regarding the facts pertinent to the property and background of the request. Board members may ask questions of the governmental agencies once they have made their statements. Then I'll call on the applicant to come forward and state their name and address for the record and present your evidence and reasoning supporting the granting of a variance. If there is no opposition, the applicant has 10 minutes to present their case. If there is opposition, the applicant and opposition each have up to 15 minutes. After the applicant's presentation, board members may ask questions of the applicant. Then I'll call for opposition or other parties who will have up to 15 minutes to speak. This 15 minutes applies to all parties, so if there are multiple parties that wish to speak, please determine how you're going to divide your time beforehand. After the opponents speak, the board members may ask questions of the opponents. Finally, there'll be a discussion of the case by the board, during which time board members may ask further questions of parties that have already testified. Then the board will make any determinations it deems necessary. Our bylaws allow an applicant at the initial hearing on a matter to request a deferral of 30 or 60 days without prejudice. In the event of a deferral of an application or failure to appear, any opponents may be heard on the record at a meeting where the application they oppose appears on the agenda. Mr. Moyers, if you would now swear in anyone who wishes to give testimony.
All right, if you're here to testify before this board, if you're here to speak either for or against any item on the agenda, please stand and raise your right hand. You solemnly swear or affirm testimony about to give be the truth, the whole truth, and nothing but the true self you got. Be seated, please.
Thank you. All right, we have agenda corrections or changes.
We don't have any agenda changes or corrections, but we would ask that we vote on items 4E, 4F, and 4G as one item, if the board so moved.
Okay, do we have a motion to do so?
Motion.
Second.
Okay, we do have a motion and a second to combine items 4E, 4F, and 4G. Okay. All in favor? Aye. Opposed? We're good. All right. All right, Madam Clerk, if you will, please read our first item.
Okay, 4B is a request of David Hensley Jr. It's to extend the current commercial CA zone boundary 100 feet, located at 6412 Maynardville Pike, CLT map 048, Group EB, parcel 018, properties zoned CA and RB in the 7th Commission District.
Is the applicant present? Okay, do we have any opposition? All right, if you would, please come to the podium, but is there any statements from Knox County Codes, zoning, planning?
We have none. Planning may have a statement.
Sorry, still getting used to this new speaker or microphones. I mean, I'll be happy to answer any questions regarding previous rezonings or land use on the property. The current land use classification on is medium-density residential.
Okay. All right, if you would, please state your name and address for the record,
David Hensley. Do you want the property address?
please.
6412 Maynardville Pike.
Is that different from your
Home
mailing address?
Yes.
If you give your mailing address as well.
2836 Gibbs Drive.
Okay, and what is the reason and evidence supporting your request?
I guess the reason is we're just wanting to add a garage on the property, and there's not enough zoning there to accommodate that in the commercial zone. And as you can see, it's surrounded by commercial property there.
How does this fall, I guess, planning codes, how does this fall within our sector plan right now?
So the property has the medium-density residential land use classification for the entire site. Part of the property is zone CA. Majority of it is RB. So the RB zone is consistent with the medium-density residential land use, but the CA zoning on the property is not. And the CA zone would not be a permissible zone in the medium-density residential. If they came through with a rezoning application, they would have to amend the land use plan to general commercial.
Okay, thank you. Ms. Longmire?
The property immediately above the strip that wants to be changed.
You need a picture, Mike.
Oh, I forgot. I've got to learn to push these buttons too. The property right there where the cursor is, what is that?
That's an apartment complex.
It is a residential complex.
Yeah.
All right, thank
Right.
you.
Ms. Garrett?
You said you were planning on building a garage on that property. Where exactly on that property were you planning on building if, by chance, you did get
So it would be,
it
the
rezoned?
back of it would be alongside the apartment complex side.
Would that affect the access road behind there in any way?
Well, I think that access road is just probably technically for that piece of property.
I don't-
There is a road there that goes to that property, because there's no road that we're
No,
seeing.
that I don't, I mean, I'm not sure what you would call it, but I would assume that that little access, because that has a Maynardville Pike address, how else would you access it because those are two separate properties located directly in front of it.
Okay, I guess I was talking about the tree line, so there's nothing there at the tree line.
Oh, no, that's just a tree line.
Okay. And is that part of Old Maynardville Highway, do you think?
Oh, I don't think so.
Okay.
I mean, there's a road on the other side of, yeah, you can see there's a road right there.
Yeah.
I believe that where the cursor is there, I think that is Knox County's right of way, so that could not be closed without county commission action.
Well, I would have no access to my property if you closed that. Right, yeah.
Well, if it were to be closed, you would retain half of what's there and the other half would go to the front property. But, it would take you signing off on that. I'm just stating that it is public right of way currently.
I suppose my only question, again, is going to be for codes or planning. So we've had this in, these requests similar to in front of us before. I guess the question I would have is zoning would not make this change, is that correct? We do have the authority to do this, and I understand that. But due to the sector plan, if it were in front of planning, it would not be something that would be approved?
I can't speak for planning, what action they would take, but the zone that he's requesting is not consistent with the sector plan.
Okay.
We had a case almost exactly like this about, I'm going to say 4 months ago, thereabouts, where we were being asked to technically rezone a piece of property by extending an adjacent zone 100 feet back in an area that did not comply with the sector plan. I don't think that we should be doing that. We declined to do that before for the various reasons that if you went before planning to ask for zoning, it most likely would not be approved because the rezoning is not supported by the sector plan. So I'm not sure why this is any different.
Ms. Garrett?
I'm going to go ahead and make a motion. Unfortunately, I'm going to make a motion to deny the request due to it not meeting the criteria in the sector plan.
And I second that.
Okay, we have a motion to deny the request with a second. All in favor? Aye.
Aye.
Opposed? Okay, I'm sorry, your request was not approved. I do have a question, Kim. Do we have signature on this application?
It's not sure.
It's not on this one, but you do have it? Okay.
Yes.
Okay. Madam Clerk, if you would read 4B. It's not. Oh, that.
4B is a request of Daniel Neal for waiver of lot intensity from 1 acre to .96 of an acre located at 2855 Grove Road, CLT map 042, parcel 150, property zone AG in the 8th Commission District.
Is the applicant present? Do we have any opposition? Okay, we have any statements from codes, planning?
We have none.
Okay. If you would please come to the mic. State your name and address for the record.
Yes, ma'am, I'm Daniel Neal. My address is 2901 Grove Road, and that's Mascot, Tennessee, 37806.
Okay, and if you would please let us know why you are here and give me some supporting evidence of why you're asking for what you're asking for.
Sure, yeah, we're requesting a variance. The original plot showed 2 acres, but where the county claims the road, it's a little less than 2 acres. So we're trying to subdivide that land into 2 pieces of property, and that's what the variance is for.
Okay, I think we're going to have a, you go ahead, Ms. Longmire.
I see that both of the properties are now 1 acre? Is that correct? Or they're
That-
less than 1 acre?
They're less than 1 acre, that's what we're requesting for.
Okay, so you just need approval, you're asking one to be less to 0.96 acres.
That's correct.
And the second one, 0.74.
That's correct.
All right, if you kept one at 1 acre, what would be the percentage of an acre for the other one, do you know? Like if you left
I
one
don't know.
alone,
I guess that'd be a question for my surveyor who's not here.
I will ask somebody in codes that can figure out that.
We would have one 1 acre lot and 1.7 acre lot.
0.7.
0.79.
Okay.
Ms. Garrett?
The lots are not currently subdivided at this time, right?
I'm
Is that
sorry?
correct? The lots are not currently subdivided at this time, correct?
That's
You're
correct.
planning on subdividing?
Yes, ma'am.
Go ahead.
Which lot were you planning on how do you want the subdivision, I guess is what?
So right there, there's the driveway going around that easement right there. That's where the line will divide them. So that's correct. So down toward the bottom of the screen there, that's one, and to the top, that's the other.
That easement is being created during this?
That's correct, yes,
Okay, and
ma'am.
why is the easement there?
Because that driveway accesses the garage to the house up on the top. So we share that driveway right now. So if you cut that off, they wouldn't be able to access the garage to that one, yes, ma'am.
Neither lot is right now, see, this lot is right now, 96 acres.
Yep.
And that is 0.74.
Yep.
And this goes to,
There, and goes there, where's this is coming off of, okay.
that comes off.
So that easement is in place, it's just not recorded anywhere at this point? Is that
Correct.
correct?
No, I'm sorry, no, I don't think so. There's two easements. One is already in place, and it's toward the very top of the screen,
Yes.
right there.
Yeah.
Got it, okay.
That's a driveway for another residence behind the
Okay.
house.
Okay. Mr. Huff?
Just so I can clear up in my own mind, both of these houses exist today,
Yes, sir.
and they're both on a piece of property that's 1.79 acres
That's
total?
correct.
Have you had any conversations with Mr. Roberson about perhaps purchasing some additional property on his side to get the property you need in order to avoid the variance?
We have not as of today.
Why does the easement, the proposed 15-foot easement, extend to his property line,
Whose property line? I'm sorry.
to Mr. Roberson's property line?
Okay, I wasn't aware that it did extend his property line.
Well, it shows it. I mean,
As far as my understanding is I own all of that right there.
no, I understand that, but there's an easement that goes from Grove Road past both of these houses and terminates at the property line between, can you zoom in, right where your hand is? So from the end of your driveway to that property line there, why is there an easement there? Is that for access for him?
So there's a camper that parks there right now. That's still the driveway. Does that make sense on what I'm saying? Or am I misunderstanding?
Are you
I
saying that
think
it's your property?
Yes, ma'am.
That's,
I think what he's saying is by putting that access easement in, you're giving access to Mr. Roberson to the rear, and it's taken away from your property. So is there a reason why that access easement has to extend all the way to the property line?
I'm not sure who Mr. Roberson is.
He's your neighbor. He's the man that owns the property to the left.
There,
Down right there?
yeah, David Roberson.
No, the house right there is owned by Jessica Neal, my sister. I bet you Mr. Roberson is the house behind me on the other easement on the top.
I'm just going from the survey map that you
Sure,
provided.
sure. Yeah, the easement on the top of your screen is Mr. Roberson's.
On
Okay.
your proposed plat, you're giving him two access easements. You're giving him one up top and one down here.
Huh. That's news to me. That must be surveyor question. I don't know. Okay.
why can't you come off Grove? Why do you need the easement? And I'm just looking at
Sure, yes,
a
ma'am.
piece of paper, so why are you not able, why do you need that easement? Why can't you both come off Grove?
The two houses that's on the plat right there, is that what you're asking? I'm wanting to sell my house, and I can't until so if we only get on the east, cut the line on one side of that driveway, somebody's not gonna have one. There's a garage on this one that's accessed by the same driveway
Yeah.
as they're accessed.
I think, Kelly, I think you had a picture, an aerial, I think, that shows the,
So if you,
I'm trying to see where all the driveways are.
where the cursor is now, that's a garage on the 2901. Right there, yeah. And then we share that driveway to her property as well, or to her residence as well.
Yeah.
Again, nothing is gonna change the way the property functions.
Right.
It's just gonna be giving her an acre or a
Right.
little less than an acre, and me a little less of an acre.
Yeah.
But everything will stay the same as far as how it functions.
Yeah, I do understand that. I was just trying to see, because I know, I think that when you have that easement, you're pulling that off of part of your land, so.
Sure.
That's making the
I have a question.
waiver a bit different. Go ahead, Ms. Longmire.
This is for planning. If we do not grant the waiver and one of the properties stays at .96 and the other property stays at .74, will there be a problem with him subdividing it since that is what it is already? If he wants to sell part of that property?
Yeah, right now, we wouldn't be able to approve the plat without both lots being 1 acre in size.
Yeah. Yeah,
Yeah, or the variance being approved.
okay. Mr. Huff?
Yeah, I just want to point out that Lot 1, which is the one on the upper side,
Yes, sir.
it falls short of about 10,500 square feet of having enough to be 1 acre. And the one below, less than that. But if you could negotiate with your neighbor to purchase a triangular piece
Back
of
behind.
property, you wouldn't need to come before this board asking for the variance.
Right. You mean, but back behind to the left of the screen, though, that little cutout
Kelly,
piece there.
can you put your cursor on the top of that line? Keep going up. Yeah. If you go from that pin, that corner right there.
Yes, sir.
come
Down to the other pin.
Come down, all the way down. Now come over to the left, right about there. If you drew a line from where his hand is to that first pin, you'd get about enough area. So if you could negotiate with your neighbor to purchase that property, you wouldn't need to ask for a variance.
Sure.
So there's things you could do to avoid having to ask for a variance.
Right. Again, I wasn't aware, this is, of that anyway.
Are you willing to do that?
Sure, if this gets, that's the only option I've got if this gets denied.
With that in mind, I'd like to make a motion that we defer this for 30 days and give him an opportunity to negotiate with his neighbor. And if that bears fruit, then this can go away.
I second it.
I have a statement about that. First of all, it presupposes the neighbor might want to do that, which would make him have to come back to us to seek a waiver. The land has been there. It has been used in that way for quite a while. We have no conflict with the neighbors at all, and because it is what it is, if we give them the waiver, it can stand 2 separate lots. If you look at the entirety of the neighborhood, it would not be a problem with the rest of the neighbors. It would not be a problem with the layout of the neighborhood. I can't support that motion because several reasons. One, it presupposes the neighbor might want to sell. Second of all, you have to pay for that. And I don't know what a neighbor would charge. It's almost like a holdup. If you will sell that to me, I can do this. Well, I will sell it to you, and as long as you pay me da-da-da-da-da. Yeah, or if she doesn't want to sell it, he'll have to come back. So I cannot support the motion.
And I have one other question. So it says the lot size is 2 acres. Is it the easements that are causing the reduction?
It's actually just under 2 acres.
Oh, I'm sorry. I'm looking at this and it says 1.96. Is that what it is then?
Yes.
One,
0.79.
where did 2 acres come from?
I believe he was saying it was 2 acres before the road right-of-way extended.
That's correct.
Before the road right-of-way
Yes, ma'am.
extended? Okay. Explain the road right-of-way to me, planning or codes or somebody.
I'm not for sure when the right-of-way would have been dedicated. 'Cause there's never been a plat recorded, so it would have had to have been done, I guess it would be a prescribed easement. I don't know when the right-of-way would have been dedicated. And listening to testimony today, though, if the right-of-way dedication caused the nonconformity, I'm not for sure even needs a variance. So I think deferring would give us time to go back and research and find out when the right-of-way was dedicated and how much property was there prior to that dedication.
I think it was probably done in the 60s,
Yeah.
perhaps. A lot of the houses are older. It's an older neighborhood, so it's an older thing. But we will have to vote on the motion before we
Yeah,
do our
we-
withdrawal.
We have a motion on the table to defer for the purposes of speaking with the neighbor. I don't know if we need to do a substitute or just add to that one to look into the right-of-way as well. Would it matter?
It could be part of the same motion.
Okay. Does anyone else have anything to add to that?
Mr. Huff,
Mr. Huff, can you add that to your motion?
Sure, I will amend my motion to include allowing codes time to go back and research the history of both the houses and the road dedication.
And I'll second that again.
Okay. So we have a motion to defer with a second. All in favor?
Aye.
Aye, opposed? No. Okay, so you're deferred for 1 month, so.
1 month, yes,
you can-
ma'am.
You talk to your neighbor and, just for some
And talk to
backup and talk to
Sure.
codes, so we can look at that and see what that does for you, okay?
Yes, ma'am. Thank you.
All right, thank you. Okay, 4C.
4C is a request of Christina Bollier for waiver to increase maximum accessory structure height from 18 feet to 23 feet, located at 8559 Pettigo Road, CLT map 027, parcel 09006, property zone RA in the 7th Commission District.
Is the applicant present? Okay, do we have any opposition? Anything from codes, planning? At this point, nope. All right. You would please state your name and address for the record?
Christina Bowler, 302 Douglas Avenue, Knoxville, 37921.
Okay, if you would please give us the reason for your request and the evidence supporting what you're asking.
All right, the request is height variance for an accessory structure. The applicant, I'm the architect representing the client who's building a house and a garage to store their RV in, so that's the accessory structure. The structure meets code prescriptively at the 18 feet if measured from, if the grade was all the way up to the slab, basically. So the reason for the ask is that the site is very topographically steep and varied throughout. So there really is no one particular obvious place to put it where we would not require some sort of height variance. this diagram is showing the height of the structure, and with that 5 feet ask is really to do with measuring from the grade where it is the most varied at the rear of the structure. The structure's set back 200 feet from the road. It's set back 80 feet from the neighboring property. It's a heavily wooded lot. We don't think that the height is going to present a negative impact to the road or neighboring properties.
Okay, thank you. Mr. Huff?
The typical section of the building shows a dimension from the bottom core of the truss to the finished floor of 20 feet. Is that actually 18?
Sorry, can you ask that again? The 18, so the 18 feet height is the average of the roof slope.
No, I'm looking at the drawings for the building itself. It's this kind of fuzzy looking drawing. Kelly, can you?
I think that may just be an example diagram
Right.
from the code.
That dimension from the finished floor of the building to the bottom chord, is that actually 20 feet or is it 18 or what?
It's 16 feet.
16, okay, thank you. And you said the maximum height on the, or grade difference shown on this sketch was 5 feet, and that's the worst, or that's the
That's the
biggest
worst
dimension?
case scenario, or at least that is it could actually be a little bit higher, but that's what the contractor feels is reasonable for final grading at that.
And
back
it's
corner.
basically at grade at the other side of the building?
I think it may be about a foot, maybe, so that dashed line is trying to show the rear grade. The front is pretty much level, so it's maybe a foot or so at the opposite corner, but the worst case scenario back, I think it's west, the westmost corner if you're looking at a map, but that's the worst case scenario at 5 feet.
So the average, I guess, the horizontal plane, and I will say for the record that if that's confusing, you are not in the minority.
Yeah.
But it sounds like the horizontal plane would actually be about 3 feet below the finished floor grade. So your actual variance would be, actually, I'm not sure it would be. If the bottom chord to the finished floor is 16 feet plus another 3, that's 19. I'm trying to figure out where we got to 23.
So I have the 18 feet is the average roof height from the top of slab. And so then if you were to figure the average
Okay.
at the topography, which I wasn't aware that was how it was determined, but I'm not sure what it would be offhand, but I see what you're saying. I think it would, so then it would be maybe 22 or so.
Okay.
CBC, Ms. Longmire?
Looking at the topographical map, it certainly shows challenges enough to try to get it in. I'm impressed that anybody can get anything. If you look at the, Kelly, if you could put the topographical map up, please. That it is not a significant enough change in height to me that it would disturb the neighborhood or look out of place. So I would like to make a motion to approve the waiver to increase maximum accessory structure height from 18 feet to 23 feet, knowing that that's the average, due to topographical issues.
Second.
Okay, we have a motion and a second to approve the waiver to increase maximum accessory structure height from 18 feet to 23 feet due to topography. All in favor? Aye. Opposed? So approved.
Thank you.
Okay, 4D. Oh, let's see, yep. That's my
4D is a request of Kelsey Henderson for waiver of rear yard setback from 15 feet to 10 feet, located at 1723 Wood Song Lane, CLT map 084, Group FB, parcel 008, property zone PR in the 8th Commission District.
Is the applicant present? Do we have any opposition? None? Anything from planning codes? At this point?
As talked about in the pre-meeting, this could be a development plan that could go before Planning Commission, and Planning Commission also has the authority to reduce this rear yard setback. So if this board so chooses not to grant the variance, the applicant would still have a pathway forward by going before Planning Commission.
Okay, do you see any issues with planning?
Planning?
I wouldn't see any with planning, no. It's not controlled by periphery, so that they have the authority to reduce down.
Okay. Ms. Longmire?
Because there would not be a problem with planning or with us, I would like to make a motion to approve the waiver.
Second.
We want to get her
What?
down here first.
Oh, do you want to say anything?
Yeah. If the applicant would come down and state your name and address for the record.
I'm sorry.
I'm sure you're in suspense for what she's going to say.
My name is Kelsey Henderson. My address is 121 Thurman Lane, Clinton.
Okay, and if you would please let us know why you're here and what you have to support your request.
I am here to reduce the setback to install a sunroom on the back of the property. That back lot is owned and community property of the HOA of the subdivision, who has already given their approval for the structure.
The community did?
Yes.
Okay. Which, of course, we have no say-so or comments that matter from this board regarding what the subdivision covenants and restrictions would say. But does anyone else have any other questions? No? Ms. Longmire?
Because the condo is built 3 feet from the setback, which gives no other options for the use, because that probably going before planning would grant this anyway, there has been no negative comments from the neighborhood, the HOA, even though we can't do anything with the HOA. They have approved it. There's no one here against it. So I would like to make a motion to approve a waiver of a rear yard setback from 15 feet to 10 feet.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
Opposed? Okay,
Thank
you are
you.
approved. We already did. Yep. Okay, we have the next E, F, and G are being read together.
Okay, these are requests of Ryan Hickey, Ball Homes. They are all for waiver of front yard setback from 20 feet to 15 feet. They're located, let's see, 4E is located at 1103 Hunter's Knoll Lane for parcel 012. 4F is located at 11041 Hunter's Knoll Lane, parcel 013. 4G is located at 11045 Hunter's Knoll Lane for parcel 014. They are all CLT maps 103, Group FB, and they're all zoned PR and TO in the 6th Commission District.
Is the applicant present?
The applicant's present.
Do we have any opposition? Okay, if you would please, oh, we do have opposition? No. I was going to say.
Yeah, he's the real applicant.
I was going to say, Mr. Hickey, I don't think that Ball Homes would appreciate you opposing this. If you would please state your name and address for the record.
Ryan Hickey, 1914 Pinnacle Point Way, Knoxville, Tennessee, 37922.
Okay, and if you would please let us know why you're here and your evidence supporting your request.
So we're here to try to reduce the front building setback from 15 foot due to steep topographical challenge on the rear of 3 lots. And we've provided a topographic map that is the as-built, that is how the current site is today. Our surveyor's here too, if you have any questions for him, but, so we own this group of 5 lots. The 2 on the ends are not as a severe challenge, so we didn't ask for any setback reduction on those. But the 3 in the middle, due to the lots being in a cul-de-sac also, pushes them further back. So, we haven't started construction here, so, I mean,
Okay.
Yeah, the slope problem.
yeah, it's just, it's all related to the slope in the backyard.
Yeah. Well, there is a bit of slope in the backyard, most definitely. I don't know if y'all have visited the lots. I did visit, and subdivision in general does have some topography issues in different locations. No one has any questions. I'll make a motion to approve the request for a waiver of the front yard setback from 20 feet to 15 feet for 11037 Hunter's Knoll and 11041 Hunter's Knoll and 11045 Hunter's Knoll due to topography issues.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
Opposed? Okay.
Thank you.
So approved.
Thank you.
All right, 4H, when you are ready.
4H is a request of Wesley and Taylor Hicks for waiver of rear yard setback from 35 feet to 14 feet at 7506 Gibbs Road, CLT map 012, parcel 08703, property zoned AG in the 8th Commission District.
Is the applicant present? Okay, do we have any opposition? Okay, if you would please state your name and address for the record.
Certainly. Clinton Little, business address is 109 South North Shore Drive, Suite 104, Knoxville 37919.
Okay. Codes planning, do you have anything you want to add right now?
I do want to add one thing is, that this is a repeat case. It was denied some time ago, 2 years ago maybe. At the last hearing, I testified that there was nothing that would prevent the applicant from filling the front ravine on the property. I have since went back and investigated, and there's a 150-foot setback shown on the plat. Before I didn't research it. Now I did some research, and I feel like there was probably a sinkhole there at some point in the past, and hence that 150-foot building setback. We don't have topography to go back far enough to see exactly what the sinkhole would have looked like in these years, but there's no doubt there was a sinkhole there in the past. The berm of that sinkhole has been removed, so it's going to be hard for me to say at what elevation the rim was. But whatever elevation that rim was, there would have been a 50-foot buffer off of it. So today he's back, and I wanted to clarify that engineering would not support filling of that ravine without there's some sort of engineering study done to prove that it wouldn't cause damage to neighboring properties.
Okay, thank you. Now, if you would please let us know why you're here and some evidence supporting your request.
Yes, thank you. And I failed to state my name earlier before the address, but Clinton Little here representing the Hicks. And so, as was just said, a bit of an unusual situation. The building is already there. Based on this significant topography, as well as a few other things that had occurred inadvertently through the build process, we find ourselves in this situation where, as I said, the building's already located there. It was placed in the only feasible location on the property that it could be due to the significant topography and the hardship involved in, moving that building, which I don't think is possible. It's a prefabricated metal structure that's already attached to concrete footings. We would ask that the variance be granted to account for the significant topography and the hardships that would result if it's not granted.
A question for either codes or planning. If the variance is granted, would he still have to go before planning for a use on review for the use of the property?
He would, and the unique situation he's talking about is this structure started out as a single-family home. That was the way it was permitted. It showed a restroom, sleeping area, restroom. It showed all the aspects of a single-family home. These pre-manufactured metal structures, they are hard to convert to single-family homes. They can't meet egress, energy requirements. So I think once the applicant got into constructing it, they realized that's too hard. So we researched and found in the zoning ordinance, there's in the ag zone, indoor storage is allowed as a use on review. So if this variance is granted, the applicant would still have to go before Planning Commission to get a use on review for the indoor storage. I would also note, if this were an accessory structure, it would meet the setback. So if there was a primary structure on this parcel with, say a single wide trailer or another residence, this structure meets those setbacks for an accessory. It just does not meet the setbacks for a main building.
My clients would certainly be willing to speak with planning to see what can be done. The bottleneck seems to be the variance. That sort of has to be taken care of first. And then working through those other issues would come after that.
Will you show that diagram, Kelly? Mr. Huff?
Yeah, I just want to see if I can clarify the timeline here a little bit. According to the factual background that's in this court filing, sometime in April, doesn't say what date, a building permit was allegedly applied for through the County Codes Administration. Then in April 12th, work began on the footers and water line, basically work to build the building. And at this point, there's discussions between the owner and codes about the building permit. And on the 14th, on May 5th, after construction had been started, petitioners received a permit. So they finally got the permit on the 13th of May after work had begun. So technically, this building was started before a work permit was issued, a building permit. And then there's a whole bunch of discussion about people who come out to inspect for different reasons, the health department, none of which have anything to do with setbacks. My question is, did the petitioners know they had violated the setback when they started construction?
No, and that's part of the issue is they had no idea. Had they known, they certainly would not have proceeded in the manner they did. It was complete naivete of the setbacks, unfortunately.
Would they have come to this board for a variance in that case?
I'm sorry,
Would they have come before this board asking for a variance?
Yes, based on the topography, yes, they would have had to. There's no doubt about that.
Mr. Huff, to clarify, we've had a policy change. Used to, when someone applied for a building permit, we granted them permission to go ahead and dig their foundation, their footers, and due to this and numerous other situations, we now do not allow any work to take place until the permit is officially issued. So we used to give what was called a grading permit that essentially said you can go grade your footers and start groundwork, but we had numerous of these, so we no longer do that. Now, it is, you can't do any work until you have permit in hand.
But in either case, beginning work before the permit's issued is a risk that the builder takes when they start construction.
That's correct. That is correct. Because we would still, on that grading permit back then, tell them what the setbacks were. So we didn't issue that permit and not tell them setbacks. They would have known the setbacks.
Okay.
And I could have explained that better in the document you're reading from. But I believe at the prior variance hearing, you know, the grade work could have been changed, you know, had that come to light that there was an issue with the setback. They could have, of course, redug the footers, you know, before anything was, any concrete was poured or anything like that. So. In other words, the work that was started could have been, you know, adjusted, dealt with.
But at some point in time, you did learn that the building was within the setback.
Yes. Now, I unfortunately didn't get involved until after the first variance meeting, or variance hearing. But the Hicks did not learn about the setback issue until the building was in, and I believe building inspector flagged it. The Hicks were under the misunderstanding that, you know, the various inspectors that come out, for example, from the health department and things, you know, unfortunately, they viewed it as Knox County instead of different departments therein, and believed that they were okay. You know, obviously, we all know that that was not the case, but the intent there was not to, you know, flout the code restrictions at all. It was simply, they thought they were doing the right thing. They thought it was in compliance, and that, you know, if the county had had any issue, they certainly would have voiced that concern through those various inspections. Of course, we know that's not really how it works, but I think the intent there is the important part. And the intent was that they didn't understand how all these pieces work together. You know, young couple trying to you know, forge a life, and learned a lesson, but you know, the intent was not to get around these things. That it was to comply. They thought that's what they were doing.
So they were building a house originally out of this building. Was that did I miss something there, Steve, on that?
No.
No,
go ahead.
Either or.
The only way, in this time frame, the only way we could permit a structure on this parcel would have been for it to be a single-family home. So the applicant wanted to build this building to store his leftover materials from his construction business in. So he showed the living space in there. This still would not meet the setbacks for a single-family home. You know, if we could go back in time, and, you know, me and Kim taking over up there, and Kelly getting involved and reading the zoning ordinance, and we were all new to this process then. If we could go back in time, we would have sent him to planning and got the use on review approved for indoor storage, and then he would have came here for a variance and then started the construction. But, you know.
So if he gets the variance today, he still has to go to planning to get use on review. If he doesn't get the use on review, and I know that really has nothing, it's just a question. If he doesn't get approval with the use on review, then what happens with the building? I mean, what does he do? Nothing?
It's got to be moved to meet.
Well,
if he doesn't get the use on review, it wouldn't be allowed there. He'd have to add, he'd have to add the apartment, or he'd have to add he'd have to add a house, yes.
Okay. Was he from the beginning wanting a house, or this was for storage and he was trying to retrofit it?
I think from day one, it was for storage, and he was trying to retrofit and make it work with an apartment in it.
Yeah.
Correct.
Can I
So, yeah.
continue looking at the timeline a little bit?
Sure.
According to the court filing, on the 7th of June, 2021, the petitioners, I assume that's your client, were notified by codes that a complaint had been lodged inter alia, and I will have to, I don't know that term, so,
Amongst other things.
okay. That the placement was within the 35-foot setback. So your client was made aware that the building was within the 35-foot setback on June the 7th. They didn't start pouring concrete until June 26th. So they had opportunity to figure out what was up with the setback. Not sure why that didn't happen.
Let me look at some dates, because I think when we received the complaint and went out there, the building was built.
Yeah, that's good.
Is he a contractor?
He is, he does small remodeling jobs under 25,000. And so, not the type of contractor, as he stated at the last hearing, that normally locates structures and things and needs to know about setbacks. That thought crossed my mind, but he just, does, at least at this point, trying to build his business up, and so,
He's just listed as the contractors. That's,
yes.
What's that permit number?
that's Steve's
So,
looking something up.
based on the reading of the statement of fact in your filing, he should have known about setbacks. It's public record. You can go to the codes and public documents to find out what it is.
Certainly.
He was told that there was a setback issue, yet continued to place concrete even after being told.
Well, and I think codes may have some information on that to shed some light on this if the dates are incorrect. But another issue that I'd mentioned earlier, some inadvertent things that came up along the way. One of which was the concrete was not supposed to be poured until the county came out and took a look at the footers. My folks were out of town on family vacation. The concrete contractor, thinking he was doing them a favor by coming and pouring concrete on a Saturday, poured it early. And the first thing my folks did when they came back in town is immediately called codes and said, hey, we're so sorry, we have a problem. They poured concrete over the weekend while we were out of town. They weren't supposed to pour concrete over the weekend. They weren't supposed to pour it until the week they came back, because they knew they needed to work with codes on getting those footers inspected, which would have caught the setback.
Again, according to your document, they said it was scheduled to be poured on the 28th of June. It got poured 2 days earlier.
Yes, and the idea was that it was scheduled in, and then, but that was presuming that the footer inspection had taken place. I can't speak to when that was actually scheduled, but if I'm not mistaken, it was supposed to be done that Monday morning, followed by the concrete being poured. I could be wrong about that, but on what day the inspection was scheduled, but the concrete would not have been poured without that footer inspection have taken place. And that's when they called, like I said, first thing Monday morning to alert codes that unfortunately it had been poured.
It was scheduled to be poured on Monday morning, though.
Correct.
So it would have been poured anyway. Codes wouldn't have gotten out there prior to the pouring of the concrete, more than likely, would they? Or was that a back-to-back schedule of the codes and then the concrete truck is just waiting?
My understanding is that's the way it would have been.
That does happen a lot, actually, where the inspection is finished and then the concrete's immediately
The
available.
truck's just sitting there waiting?
Thank you.
Well, that's pretty convenient.
I can only assume it limits the time that an open footer is exposed without the concrete being filled.
It looks like we had a violation stop work order scheduled for May 25th of 2021. The inspection got canceled for some reason. I don't know why, but I suspect that something had to be taking place on that date, or we wouldn't have got a call to come out for an inspection, or, a violation notice, so.
Do you have a record of this June 7th email about the complaint?
There's nothing in the file, and it's our old system, so it's really hard for me to search it. But I don't have any records of that, I'm sorry.
Right now on the building.
The complaint was entered by Becky Acuff, who was our office administrator. She's since retired, so I wouldn't even be able to go back and search and find it for you.
What are they needing? I mean, it says they need the variance from the mandatory setback requirement. What is that?
The mandatory for a main building for the rear is 35 feet, so the board would need to grant the variance from 35 to 14 if you
14,
chose
okay.
to do it.
That's what I was looking for, okay. Okay. Mr. Huff, did you still have,
No, I'm done.
you done? Does anyone have anything else they want to add or help
Actually,
out with?
Actually, I do have a question for our council.
Okay.
If we grant this, what does this do with this court filing? Are we agreeing to the issues brought up in this court filing if we approve this? There's some pretty serious allegations in this court filing having to do with fraud and a variety of other things.
If you grant this variance, my feeling is that the lawsuit is moot as far as the county goes. Mr. Little?
At the very least, to that central issue, the variance, absolutely. There remains that issue of use on review that, as an attorney, never want to give up an issue prematurely, but assuming that can be worked out as well, which my folks are more than willing to do, to work with planning to find a way to bring the use of the building in conformity with the code, then I think.
Well, use on
I don't
review
feel
would
like
be with the planning commission.
Yeah.
So.
That's not,
Planning is planning. This is the Board of Zoning Appeals. You didn't accuse planning of fraud. You accused the Board of Zoning Appeals of fraud.
The indoor storage is a pretty straightforward use on review. I can't never recall one getting denied. Can you, Mike? I mean, it's pretty well, you meet these requirements and you get it, but I'll let Mike speak to that.
well, if they follow the requirements.
Well, there's not many requirements in the actual zoning ordinance. There was a lawsuit, or at least a rendering from a judge saying what indoor storage is supposed to be and how it's supposed to be used. And so we use that as guidance through the use on review process. We still look at plan document recommendations, various other things that go into use on review. So there's no guarantee of approval, even if you check every box of, so I can't
Mr.
guarantee
Huff?
anything, unfortunately.
I'm sorry, are you looking at the language in paragraph C of, subparagraph C of paragraph 41? When you talk
Yes.
about fraud?
Yes.
Okay, that's just lawyer's language. When you're challenging the administrative action of a board, the standard that the court must find is that the board acted arbitrarily, fraudulently, or illegally. So when he says that, he's not saying that this board committed a fraud. These are terms of art that are used in certiorari lawsuits. So I wouldn't take that personally. That's just the standard that he has to meet in any challenge of the board. So when it says illegal, doesn't mean you robbed a bank. This is lawyer language, and I think that you don't need to say or assume that he is saying that you guys acted fraudulently. This is in every case that challenges the BZA, or in any case that challenges the Planning Commission, you're going to see a request that the court find that the body acted illegally, fraudulently, or arbitrarily, because that's the legal standard. So.
Thank you.
And I wanted to add, at the last meeting, there was lots of concerns about a commercial business being ran out of this building, this structure. That's not what the indoor use is for. If Mr. Hicks gets approved here and he chooses to run a commercial business out there, I've got Ms. Harvey back here who is willing and ready to handle that. So, we will ensure that he meets all the conditions of the zoning ordinance, if approved. I'm not lobbying either way, but if he were approved, we have mechanisms in place to make sure he follows what's in the zoning ordinance.
I'm sure this has been asked and answered, but I'm going to ask again. So if we do not approve the request from the 35 to 14, he still needs that in order to go to use on review, is that correct?
If you don't approve the request, I don't think we would move forward with the use on review. His only option at that point would be to put a single-family home on the parcel to go along with the structure, and then he wouldn't need the use on review for indoor storage at that point, because it's his garage on his property. He could store what he wanted in it.
Okay. Ms. Garrett, is your light on, or is that, okay.
It looks like there was a use on review that was filed back in earlier in '22 and then withdrawn in March of this year. Was that because he was told he needed to come here first?
Yes, that's correct.
Yeah, so the application was tabled in 2022. We can only table an application for 1 year. After 1 year, it gets withdrawn.
Ms. Longmire?
But just to make sure, if he did put a single-family dwelling, which could be a mobile home, for example, on that property, and it becomes strictly a storage shed, for want of a better word, he still would not be able to run a commercial business.
He would not, but then he could store his materials in his personal property at that point. It would be a legal conforming structure that he could store his material in.
Inside or outside?
The use on review is for indoor. I think we would, yes, it would still have to be inside even without the use on review.
And that's the intent's not to use it as commercial. It's just storage and staging of materials inside. So.
Does anyone else have any other questions, comments?
I will make a motion. I move that we approve the variance from the mandatory setback requirements pursuant to the Knox County zoning ordinance from 35 feet to 14 feet, with the understanding that the applicant must also appear at planning to apply for a use on review.
That's second.
We have a motion and a second. All in favor? Aye. Opposed? Okay. John? Correct. Okay, the request has been approved.
Thank you.
Hey, Ms. Kerr, we had a question and maybe we missed it down here. Did we vote on the minutes at the beginning of this meeting?
We did.
Okay.
Yeah, we did.
Perfect. We
Okay.
must have been daydreaming down
We
here.
were. The only other thing we have is to, we have our bylaws that we've been working on for a couple of months that have been,
Thank you.
thank you. It was already withdrawn, yeah. We may not have stated it, but the deferred item was withdrawn, correct?
Do you want to say that?
So we will
Yes, the
say.
deferred item was
So the
withdrawn.
deferred item, item number, excuse me, I'm sorry. The deferred item of 5A, request of call award, has been withdrawn. Okay. 5A. Yep. So we now need a motion to approve and adopt the revised bylaws.
Make the motion to approve and adopt the new bylaws.
Second.
We have a motion and a second. All in favor? Aye. Opposed? Okay, so approved. All right, and we will now motion to adjourn.